Now, it's AM 650's The Law Show, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show here on AM 650. Our guests in studio are David Hobbs and Ian Giroday from Hobbs Giroday, Vancouver estate litigation lawyers with offices downtown on Howe Street, right across from the courthouse. Gentlemen, welcome. Happy New Year. Good to see you both.
Happy New Year, Sterling.
Happy New Year, Sterling.
Survived Christmas. That's good. It looks good on you. And we're ready to turn the page in a couple of days here and start 2014. And in the matter of wills and estates and planning and all of that sort of thing, I thought it might be a good opportunity to go sort of through the nuts and bolts of what Hobbs Giroday is all about, the sort of work that you do and the clients you represent and the processes that are part every day of the work you do. So first, tell us a little bit about Hobbs Giroday. David, tell us about the firm and how you and Ian got together and how long it's been going.
Well, Ian and I have worked together for many years, but Hobbs Giroday, we formed that as our partnership in 2005. Our offices are on Howe Street across from the courthouse. A major part of our practice is estate litigation. We help people with estate disputes and also people who are involved in the process of the application for grant of probate or administration, which is someone's passed away and
Right.
the whole process of administration of an estate, whether it's with a will or without a will. And it might be the executor, it might be the administrator, or it might be one of the people waiting for the benefit of this exercise.
Mm-hmm.
And we meet with people. Usually they have some problem that's bothering them, and we delve into that problem, try to solve it for them.
Ian, one of the things that Hobbs Giroday does not do is draw up wills. Those are done by other law firms and other lawyers. You deal with the aftermath of the will, the disputes aspect of the will, correct?
That's correct, although we do also help administrators or executors apply for probate with the court, and really that involves filing certain documentation with the probate registry of the Supreme Court of British Columbia to prove the will and to get the executor named under the will duly appointed.
Okay.
And that process allows the executor to then go forward and deal with the banks where the will makers' accounts were, and
Right.
the land title office regarding any real property they owned, and so forth.
Now, you've talked about proving the will. What do you mean by proving? You mean proving that it's in fact a valid will in the first place?
Right. It proves that it's one, it's a valid will, and two, that it's the last will, because of course some people die having left a series of wills.
Well, it used to be, and again, I'm kind of dating myself old school here, David, but there was a time when this document began with this is the last will and testament of John Smith, being of sound mind and body. And I know I'm probably going back to your early days of law school, but it's essentially what proves a valid will, isn't it?
Well, there are many things that prove a valid will or disprove it, but the concept you're speaking about, wills usually begin with the statement that the person says, this is my last will. The other thing they usually say is, I hereby revoke all prior wills.
Aha.
It's for further clarity. So if I've made a series of wills, I'm saying those wills don't matter anymore. This is the last one, and I begin my will statement in that regard.
In the normal passage of a person's lifetime, Ian, would a person likely make more than one will as their economics, their family circumstances, etc. change, or do most people just make that one will and that's it? We're good.
Yeah, I would say that more often than not we see cases where there's been earlier wills. As you say, Sterling, circumstances change, children are born,
Mm-hmm.
people die, assets can and fortune can vary significantly, and every 10 or 15 years or even more recent, closer in time than that, you'll see people change their wills. On the other hand, I mean, we have had cases where we're dealing with wills presently that were made in the 1950s.
Interesting. And of course, I recall a previous conversation. This goes back to last summer, and I was just on and on about how astonishing it was that it was in the paper. So it must be true, that there was some stat about how over 50% of British Columbians do not have a will. And I thought that was rather a staggering number until you both reminded me, well, that a large portion of that percentage of the population are kids, young people. I didn't even think about a will in my life until my first child was born. I was 30. Prior to being 30, the idea of a will was something old people did, and forget about it, I'm just nowhere near that point in my life. Is that a pretty typical age for a person to kind of start thinking will, at least, Ian?
Very typical. I suspect that's about the first time I made a will as well, Sterling, is when my first child was born. You know, one of the things that I suppose we shouldn't forget is when you're in your 20s, you're not thinking about dying.
No,
One,
that's true.
You're immortal, and two, you don't have any money anyway, so you don't need a will.
That's right. All you've got is student loans. That's right. Talk to us about a valid will, David. What determines a valid will, and what would you two go to court saying, no, that's not a valid will at all? What legal legs do you stand on, one way or another, to determine a valid will?
Well, I think the starting point of that discussion is the Wills Act. It's a piece of legislation which sets out certain requirements to have a valid will. Things like in writing, witnessed appropriately by two witnesses. There's a mechanism in the Act for how a will is executed and how the witnesses sign it. Fundamentally, everyone has to watch everyone else sign together at the same time.
Okay.
So a will, because it's a special document, the law requires two witnesses, and they both have to see the testator sign it, and then they both have to sign in the presence of each other and the testator. All sounds very convoluted, but really it's just a very elaborate sort of extra signing, witnessing process to avoid any issues about the execution. And so there are other requirements, but those are some of the basic requirements to have a valid will. And the thing about the Act is if you meet the requirements of the Act, then the law presumes certain things. For example, if the will is executed properly, it's presumed that the person who signed it knew and understood the contents of the will and did so voluntarily.
That's reasonable, yeah.
And that's just to get away from all the process that would be required to prove all those things, which would take a lot of time and a lot of money and a lot of... So it's an administrative thing where the law has created a mechanism to sort of overcome what would otherwise be things that would all have to be proved.
Okay, now let's, this kind of hits a fork in the road here, and I want to talk about a couple of things, because so far we're talking about a will as a legal document that a person sits down and does in the presence of a lawyer and a couple of witnesses. There are other approaches to making wills, one of which is an online do-it-yourself kit. You can download it off the internet. You can buy it at the drugstore. And Ian, are these if the procedure that David's just described, the appropriately witnessed and all of the T's are crossed and the I's dotted, is a will kit as valid in court as a lawyer-assisted document?
It certainly can be. Will kits have been around for quite a while now, and people use them, and many of them are accepted as valid in the court. The problem with them, there can be a number of problems. One is you may not get much of an education along with the form.
True.
For example, you may not have a lawyer saying to you, "Oh, you're engaged." Well, unless the will that I'm making for you is in contemplation of marriage, a marriage revokes a will.
Oh.
Or, you're leaving your estate to 3 of your 4 children and completely disinheriting the 4th. Let me tell you about the Wills Variation Act.
Mm-hmm.
So
this is valuable information you don't get with a do-it-yourself approach.
Correct.
Okay.
And then, I'll leave it at that.
Oh, okay.
Well, the one that comes to mind to me is, I see that you're making a gift in the will to one of the people who, and the lawyer would know this, but the problem would be that the witness to the will would also be receiving a gift under the will. Oh. And that gift would be void because the person had witnessed the will. So the people without the lawyer would not know this and might create a will that suffers that problem.
Interesting. So if I'm, so my best buddy calls me over to the house one Sunday afternoon to witness his will. Okay, we're gonna have a few drinks. We're gonna have dinner, and before dinner, I want you to formally sit down and witness my will. And so and so will be here. I need 2 witnesses. Okay, fine. So I go to do that, and then I'm told at dinner that and there'll be a little something for you in the will too. Because I've witnessed the will, I'm now in a conflict of interest situation, aren't I?
In a sense, but the specific thing is that gift's void if you're a witness.
Oh, okay. So that little something that I was told about at dinner isn't going to happen.
Right. And you may not have been told about it too, and it's still not going to be good.
Interesting. Okay. Right. So now the other option, aside from the do-it-yourself, clearly not your favorite, Ian. The other option, and it happens all the time, and it crosses your desks all the time, is when a person dies, David, and there is no will. What happens then?
Lawyers refer to that as an intestacy. That's the fancy word for no will. And when the person dies, now we have no person appointed to be the executor.
Right.
And we have no instruction as to what's to happen to their estate. So we're looking at the Estate Administration Act, another of our many thousands of pieces of legislation. And it provides for a process to appoint an administrator, which is the same as the executor, right? It's the person who's going to deal with everything. And it then provides how my estate will be distributed. And if I have a wife and children, then there'll be a sharing of the estate according to the Act between my spouse and my children. If I have no spouse or no children, then it'll be my parents. And if I have no parents, then it'll be my brothers and sisters, and so on.
There's a sort of a template then in place that applies when there's no will after a person dies.
That's right. And that's the distribution you'll get. What the Act says happens depending on who's around that are these types of relatives or my spouse.
Okay, and now the difference there would be, I think, if I have a will, I have the luxury of requesting and appointing an executor, someone I usually would know and trust to some extent to manage my affairs after I'm gone. If I haven't done a will and I don't have that, the court will take that and appoint someone to do that job, right?
Well, I don't mean to correct you, but someone has to apply to be appointed. So someone steps forward and makes the application. If no one does, which would be surprising if there's an estate to be enjoyed by somebody, presumably somebody will come forward to try to get the benefit of that estate.
And so do you apply to the court to become the administrator?
You apply, and the court would then make an order that you're appointed the administrator of that estate. If no one came forward, and we've seen rare circumstances of the poor person dying in the hospital, there's no relations.
Yeah.
They just happen to have a few $100,000 in the bank somewhere, notwithstanding they're living on the streets or who knows what. Very unusual.
Strange cases, yeah.
Then it would be the public guardian and trustee that would probably be appointed. So the government, in effect, representatives would be appointed to administer that estate.
And of course, Stuart, the other Sterling, the other significant advantage to a will is you're saying how your assets will be gifted, not a piece of legislation.
And a lot of wasted time and money to get to the point of just dealing with it.
Back to the conflict of interest, if I can, for just a second. If I'm witness to a person's will, and I'm gifted in some way in that will, that's gone by virtue of my having witnessed the thing. So I wrote myself out of that script. If I apply in a case where there is no will, if I apply to become the administrator of that estate, and I'm named in the estate as some kind of beneficiary, am I going to be allowed to be the administrator?
It's typical that someone who has an interest in the estate pursuant to the provisions of the Act, the Estate Administration Act, to apply.
Oh, I see. So I would be expected to step up.
Yeah,
okay,
no,
let's get these wheels turning here.
Yeah, no, and it's very common for an executor named in a will to receive a gift under that will. It's just the witnesses of the will who are excluded.
That's an odd little technical detail, isn't it, David? What would the reason behind that be? Have witnesses exerted undue influence in the past and have been known to be, well, less than honorable at all times?
Well, I mean, it's a subtle point, but the witness would be inclined to say what was necessary to make that will a valid will. And because there's a gift in the will for the witness.
Right.
And so it taints their their testimony, if you will, or evidence regarding the execution of that will. I mean, you get funny situations where people just don't respect the law, so to speak. So I'm filling out the form at home, to use your example.
Right.
I have my neighbors to come over, and we all know that we're all supposed to be together when we sign it. But I decide I'll go to the beer fridge while Fred witnesses it, and I'll come back. And you end up in a battle about that will, and you look the person in the eye and say, well, were you really in the room and really looking at the witness and the testator when they signed, or did you go out of the room? And the person might say, well, I did go to the bathroom while they were signing it.
Right.
And boom, you'd have a will that's not validly executed, and that'd be the end of that will.
Interesting stuff.
So the little things matter.
Well, and lawyers matter. I think that, this is the law show, and it's not a coincidence that we arrive at this conclusion on this program, but lawyers matter. And when you're talking about estates and planning for, well, when you're literally not here anymore, and making sure that those people in your life that you cherish the most receive the benefits such as you can dispose of them, of your life. Well, why wouldn't you? The technicalities here are there for a reason, and lawyers are there for a reason, and kits are just not, it's possible they will be accepted by the courts, but you're really not doing yourselves any favor by spending $50 at the drugstore or $29.95 online, because you really, I think, Ian, just judging by the expression on your face, boy, are you asking for it.
Well, it's your old, penny wise, pound foolish issue.
Yeah, exactly. Our guests in studio, Vancouver estate litigation lawyers David Hobbs and Ian Giroday. The firm is online at hobbsgiroday.com. And we're back with more on The Law Show here on AM 650.
There's more of the show still ahead. This is AM 650's The Law Show.